पे एक ऑर्डर ड्रॉ कर लेंगे। पंकज जी को बोलेंगे आज वाला जजमेंट में नहीं हो रहा, उसको पोस्ट टुमारो करके एक ड्रॉ कर लेंगे ऑर्डर और कल चला
May I please also seeking permission to file supplementary supervisory matter registered tomorrow at supplementary authority.
आपसे बात नहीं करते, आप बात नहीं करते पोस्ट मास्टर से, तो ये सब चीज़ को मेंशन नहीं करना, आपका अधिकार है, आपको जो मर्जी फाइल करो अनलेस देयर इज एन ऑर्डर नॉट टू फाइल।
From supplementary list, this is for final sole item 1, first appeal date of 2024.
First half में somebody has mentioned he is not there. अब बताइए क्या कैलकुलेट कर लिए?
Calculate कर लिए. Para 12, I discussed in the judgment. They have given the rate of non-deluxe.
ऐसे नहीं होता, फर्स्ट अपील रिकॉर्ड से दिखाइए।
Yes, record से ही, record से।
बताइए कहाँ है कैलकुलेशन शीट आपका?
Calculation sheet actually हमको जो record में है वो हमको नहीं समझ में आया। Very fairly I am saying.
आपको नहीं समझ आया
नहीं,
तो कौन समझेगा?
मगर जो I have consulted with
Senior.
yes, Lord, he has said, Lord, the finding of the court, Lord, in para 12, that is with regard to the exhibit 7 is there, which shows the rate of the building structure. The court below has rejected to give the building commercial place as a deluxe, but they have not calculated the entire area. They have calculated only the
ये
first
लैटिन
floor.
हमको समझ में नहीं आ रहा।
हम 3 दिन से पूरा एलसीआर को ई करके पूरा ई कर रहे हैं, किसी तरह
जब
कैसे
आपको
कैलकुलेट।
यही लिखाएंगे कि आपको समझ में नहीं आ रहा है।
I had consulted him, so I was trying my best to कैसे क्या। I was asking the concern जो
आपका क्या कहना है कि हम होमवर्क करके आए?
नहीं, होमवर्क करके नहीं
फिर क्या
आने के
करते
लिए हम कंसर्न जो है लैंड एक्विजिशन का जो डीलिंग करते हैं क्लर्क वहां
आपको
से
समझ आया?
हमको जो पॉइंट देखना था उस पॉइंट पे देखेंगे, उस पॉइंट पे तो कुछ नहीं।
वो फाइंडिंग नहीं है, ये तो कंफर्म है। क्यों नहीं दे रहे हैं इसका कोई फाइंडिंग नहीं है। ये तो जो
क्या सिर्फ ग्राउंड फ्लोर का दिए हैं ऐसा फाइंडिंग है?
नहीं, ये ऐसा फाइंडिंग ही नहीं है।
हाँ तो इसीलिए ना पूरा बिल्डिंग का दे दिया।
हाँ नहीं, एक ही फ्लोर का दिया,
कैसे?
एरिया एक ही दिया। टोटल एरिया इज 382.15 स्क्वायर फीट।
कहाँ लिखा ऊपर का एरिया अलग से होगा, नीचे का एरिया अलग से होकर दुगना हो जाएगा?
If it is, the rate is there per square feet construction area. The construction area per square feet. If it is
कंस्ट्रक्शन एरिया फर्स्ट फ्लोर का क्या कंस्ट्रक्शन एरिया जुड़ के दुगना हो जाता है?
yes, that
नहीं
will be.
नहीं, ऐसा नहीं, ऐसा नहीं है।
जो इसमें-
फर्स्ट फ्लोर का कंस्ट्रक्शन इज कॉस्ट ऑफ कंस्ट्रक्शन इज लेस देन हाफ।
तो इसका ये नहीं, रेट नहीं ये किया। I was trying
एविडेंस कौन देता? आप ही को देना था।
नहीं, that has to be land acquisition जो रेफर किया एग्जिबिट, they have not brought any documents on record. जो डॉक्यूमेंट ऑन रिकॉर्ड पर है उससे हम वेरीफाई उस पूरा कैलकुलेशन देख रहे हैं। हाउ दैट खाली पेज 5 ऑफ द एलसीआर में काइंडली बी सीन दैट विल या नहीं तो आई वाज कंसल्टिंग द क्लर्क देयर। अगर हमको कुछ कर दे वो लोग ऑफिसर लोग कैसे कैलकुलेट करते हैं तो आई कैन बिकॉज हम भी आई वाज ट्राइंग फ्रॉम लास्ट 3 डेज हम एलसीआर इनसे रोज बैठ के 1 घंटा तक हम पूरा देख रहे हैं हाउ दे हैव कैलकुलेटेड। कोई ये नहीं मिल रहा है हमको, ट्रैक नहीं मिल रहा है कैसे कैलकुलेट करना है। ये वेरी फेयरली आई एम सबमिटिंग।
मिस्टर राहुल, हैव यू सीन दैट
Yes, I have.
रिकॉर्ड? ये देखिए 19 से असिस्टेंट्स
Yeah,
लेकर।
I've seen it.
हाँ, क्या किया है लोग कैलकुलेशन?
हाँ।
गड़बड़ कर दिया।
Once he says, that your lordship may see page para 12.
Of the
Para 12 of the
Impune judgment.
impugn judgment.
after approximately 5 lines, 5 to 6 lines, he says, hence I find that the compensation was not prepared by the land acquisition officer, they were according to law, since it has come in cross-examination of so and so, that no map for preparing any building has been passed by the municipality, hence petitioner objectors are not entitled to get compensation for deluxe building apartment, rather they are entitled at the rate of building with RCC roof. Here he may be right. So he is not taking the account the rate of the first category, which is for deluxe category.
Okay.
So he is taking the account second one, but then it appears that what he says, Exhibit 7 shows that the value of the building with RCC roof as 3051 per square feet and acquired land is 382.8.5 square feet. So the valuation of acquired building comes to rupees 3051 into 382.5. That means he is not even considering the second. So I am not
even
aware.
considering the
Because he only says that the total area of the acquired land is 382.5 and therefore he is taking constructed area of the one floor only. This I am not yet come to know whether it is an admitted fact that second floor
Yes, it
was
is
there.
admitted.
No, it
If
is an
it was
admitted
admitted,
fact.
then the second floor was liable to be taken into account for calculating the entire cost.
You see, when they say that this much is the ये 3051 कहाँ से आया?
ये exhibit 7.
बताइए एग्जिट. ठीक है, थैंक यू. विल सी.
Yes.
हाँ, बताइए.
Exhibit 7 is there. Rate chart is there. That is
पेज नंबर.
mark here. My exhibit 7 mark here. Yes. There. The rate chart is there. The deluxe, simple, commercial, last position. Commercial. It is a commercial building. It was a commercial building.
Where is your claim? आपका claim कहाँ था?
Yes, claim from my petition is claim was 40 lakh with regard to the
You were the objector.
yes, I
कहाँ लिखे हैं आप बताइए.
that I am saying. In paragraph number the objection petition filed in the court below, page 18. It starts from page 17, subparagraph 5. That part of superstructure building of the objectors which has been acquired.
कहाँ से पढ़ रहे हैं?
Lower court objection was filed in the
यही तो
court.
हिंदी में objection है.
नहीं, it इंग्लिश में वहाँ पर फाइल हुआ है. It is there in the record.
प्रधान जिला एवं सत्र न्यायाधीश सब प्राधिकार दुमका. याचिकाकर्ता आपत्तिकर्ता रविंद्र कुमार राय.
This is objection. English objection is there on record. अगर मार्क करके हम दे
तो
देते
हिंदी ऑब्जेक्शन दिख रहा है.
हैं, इंग्लिश वाला भी है ऑब्जेक्शन पिटीशन.
दिखाइए. ये क्या है? डिपोजिशन है ये क्या
ये
है?
डिपोजिशन था.
तो उसी से देखेंगे. चलिए बताइए क्या है आपकी डिपोजिशन.
May I read that portion with regard to इसी प्रकार आपत्तिकर्तागण 2 मंजिला मकान का भाग जो एक सुपर स्ट्रक्चर के सामने 382.5 वर्ग फीट का है, जो मुख्य मार्ग के किनारे है, उसका सरकारी दर इज क्लेमिंग एज पर द डिलक्स 5302 के प्रति वर्ग फीट के देय है। तदनुसार आपत्तिकर्तागण को अधिग्रहित 2 मंजिला मकान का मुआवजा 20 लाख इतना प्रति एक मंजिल का हिसाब से 40,56,030 होता है। इस प्रकार आपत्तिकर्तागण उक्त 2 मंजिले सुपर स्ट्रक्चर का मकान का They have given objection on the basis of superstructure as per deluxe rate.
They have given that was the prayer.
That was
it
a
should be
claim.
given at deluxe rate.
Yes.
But they have given it at whatever rate they have given. So far as the rate is concerned, you don't have much objection.
Much of it. Now
but what
even
you want is that
it
the
should
first
be,
floor should also
oh
be.
yes, calculation.
The first floor
Floor
का
wise
same
they
rate
have
होता
to
है.
give. Yes.
Same rate होता है first floor का.
वो तो as per rate अगर जाएगा तो per square feet तो वही rate होगा. There is no such a different rate given in the exhibit 7.
कहाँ लिखा है कि floor wise होगा?
It is as per
Common sense से नहीं चल सकता है. कहाँ लिखा है कि floor wise होगा?
डीलक्स का स्ट्रक्चर को देन एग्जिबिट से देखने से भी फिर पूरा वो नहीं मिल रहा है हमको एग्जैक्ट कहाँ पर है, मगर इट सीम्स टू बी कैलकुलेटेड एज पर द टोटल एरिया कंस्ट्रक्शन। मतलब सिर्फ ग्राउंड लेवल, इफ इट इज ए 10 स्टोरेज बिल्डिंग they will calculate only ground level and they are giving that is
So this is the square feet area. Whatever has been mentioned is the plinth area.
plinth area, that is 382 point is the plinth area.
बताइए क्या बोलना है?
एक फ्लोर का तो मिला, दूसरा फ्लोर कैसे कैलकुलेट किया उसमें भी कुछ नहीं मिला।
वो तो दिए ना, आपके ऑर्डर में है क्या?
Order में कहीं
नहीं है ना?
कहीं
ऑर्डर में तो नहीं है ना?
ऑर्डर में दो एक ही फ्लोर का तो दिए।
एक ही फ्लोर का जैसे फर्स्ट फ्लोर का क्या हो? Is it in dispute that there was first floor also?
The dispute notes is not there notes. We have calculated only as per square feet notes they have.
स्क्वायर फीट तो ठीक है कैलकुलेट कर किए हैं.
इवन
लेकिन is
रेट
there
जो
any
दिए
dispute?
रेट है, हम उसको अगर ये भी कर लेते हैं जो रेट दिए हैं उसी रेट से भी डबल हो जाता है।
आपने इनके ऑब्जेक्शन का रिप्लाई फाइल किया होगा ना लोअर कोर्ट में? WS होगा ना आपका? क्या लिखे हैं बताइए? What was your WS? बताइए आपका WS क्या है?
कॉपी तो रिकॉर्ड
आप बताइए, नहीं पता आपको? इम्प्यून ऑर्डर
notes only para 12 with the related notes.
पैरा 12 नहीं, इम्प्यून ऑर्डर में WS का जिक्र है.
पैरा 4 में है डिस्कस।
Notes para 4 में पढ़ दें।
हाँ पढ़िए.
The case of the respondent state as submitted by the government period is that the contention and avowment raised on behalf of the petitioner's objector in his written statement is hereby denied and disputed, save and except those which have been specifically been admitted by the answering respondent in the present written statement. Respondent has admitted that the said land and the building has been acquired by the and said the land building structure situated at Moja Marichak, JB number so and so, marked as Basori land as claimed by the petitioner, but their khatiyar is with CBI. And as per the report of CU Devgar by letter number so and so dated 9/8/2018, the amount of the compensation and the building has been ascertained in legal and genuine manner, pursuing the land
as rightly non-transferable in nature, and the record of right is not available as it is with the CVM. It is further submitted that the amount has been ascertained as per the rate of non-transferable nature, and the land accordingly, although situated of the land and the structure of their is beside the circular road within Devgarh town, and the statement made about the structure and the use of building is correct, but documents are available. Documents made available on record is not proper ascertain the claim of the petitioner. It is further submitted that the application of Section 26 of the Act 30 of 130 is not applicable when settlement of nature of the land is concerned. The right is not very clear, and the respondent also rebutted the other claim on the petitioner objector. Hence, it is prayed to accept the written statement of the respondent and pass necessary order. The main objection of
written statement है कहाँ?
है
therefore the main objection of
एक सेकंड रुक जाइए written statement. The objector.
yes
आप बताइए तो आपका ऑब्जेक्शन का कौन कौन सा पैरा रेलेवेंट है? पैरा 3
yes para 3
डबल स्टोरीड बिल्डिंग,
Yes.
करेक्ट? थ्री का क्या जवाब है? कोई जवाब ही नहीं है.
कोई जवाब नहीं है
पढ़िए तो 10 पढ़िए जरा
Simple.
जवाब पढ़िए इनका.
सिंपल ये करके ई का पैरा 3 उसके बाद डी का 1 जो मेरा ऑब्जेक्शन है D1
D1 मतलब किसका D1?
मेरा ऑब्जेक्शन कर दिए सब पैरा भी है 3 में पूरा 3 में बहुत सब पैरा भी है
नहीं ये ना ये आपको समझ नहीं आ रहा है कि इतना अलग अलग डॉक्यूमेंट्स कहाँ से आ रहा है. ये एक ऑब्जेक्शन यहाँ पर है. दिस इज फाइल बिफोर द प्रिंसिपल डिस्ट्रिक्ट जज ऑब्जेक्टर.
Yes.
यही डॉक्यूमेंट है क्या आपका? दिस वन. इसमें एक अलग ऑब्जेक्शन दिख रहा है, इसमें एक अलग टाइप का ऑब्जेक्शन यहाँ दिख रहा है. ये डॉक्यूमेंट देखिए, बताइए तो कहाँ आप पढ़ रहे थे?
It is 14-10-20. The objection was filed on 14-10-20.
एक 5-10-20 एडवोकेट.
See,
ये दोनों डॉक्यूमेंट तो एक ही लग रहा है. कितने पैराग्राफ कितने लाइन? दोनों डॉक्यूमेंट्स हैं. WS में इसका क्या जवाब है आपका? आपका पैराग्राफ नंबर 5.2
2A. It is divided. Objection में 2A का
2A कौन सा रनिंग पेज बताइए अपना?
running page 3 से running page 3.
थ्री
3 नहीं है 2A.
रनिंग पेज 3
Yes.
पैरा
2A.
नंबर 2
2A.
2A.
Yes. For better appreciation of the facts involved.
ठीक
Yes.
है, admittedly.
Admittedly. Thereafter, page 6. Yes. page 7.
ये जो सीओ का कोई जो रिपोर्ट होगा अबाउट द बिल्डिंग एंड ये रेट और असेसमेंट, वो कौन सा एग्जिबिट है?
That is along with the reference letter. It is there. Reference के साथ exhibit 551 5 till 5/3 is the photographs of the building. That is exhibit. That has been-
फोटोग्राफ कहाँ डिस्प्यूटेड है कि डबल स्टोरीड बिल्डिंग है?
ये double
लेकिन
story.
हम जानना चाहते हैं जो असेसमेंट किया है वो पूरा बिल्डिंग का किया है पर स्क्वायर फीट के हिसाब से कि क्या किया?
नहीं सिर्फ
वो कौन सा एग्जिबिट है?
that has the state has not marked any exhibits. They have only filed the objection, and all no documents or oral evidence has been adduced on behalf of the state. The reference paper is there, Lord. That is it starts from page 4 onwards. 5. That reference letter by which it has been referred by the land acquisition officer to the authority. The
ये तो शुरू ही हो रहा है रिकॉर्ड ऑब्जेक्टर का ऑब्जेक्शन से। क्या नाम है?
Ravindra Rai.
कहाँ है आपका फोटोग्राफ सर? कौन से रिकॉर्ड?
Exhibit 5 record list of exhibits और इसके साथ
Exhibit 5 to 5 5 to 5
एग्जिबिट 5।
5 to
5
5
5 2 3.
ये तो आपने फाइल किया है कि उसने फाइल किया है? रिस्पोंडेंट ने फाइल किया है।
ये हम लोग
रिस्पोंडेंट ने कोई डॉक्यूमेंट
नहीं कोई डॉक्यूमेंट्स कोई नहीं.
आपका होल्डिंग टैक्स में एरिया ऑफ कंस्ट्रक्शन रहता है?
वो तो बड़ा एरिया था और जो एक्वायर हुआ है उतना है, उससे और अंदर भी मकान है. एक्वायर पूरा लैंड एक्वायर नहीं हुआ है, सिर्फ आगे का पोर्शन उतना है. It is may kindly see the notification by which land was acquired. There also it is given, dated 6/11/2017, serial number
Exhibit
8.
number? Exhibit 8.
Yes, no, their reference letter that containing all the notification and everything that by which it has been referred.
ये reference letter कहाँ है फिर?
ये ना, समझिए।
रविंद्र राय
Yes,
मकान
yes.
कहाँ लिखा है डबल स्टोरी? डबल स्टोरी सिंगल स्टोरी तो ऐसा कुछ भी नहीं लिखा है।
ये नहीं, मकान सहन में सहन, मकान में सहन, मकान में सहन, सब में वही लिखे हैं सब। कोई 3 स्टोरेज भी था वहाँ पर जिनको पेमेंट हुआ है, एग्जीक्यूटेड डॉक्यूमेंट्स।
किसी को दिया है डबल स्टोरी?
हाँ, they have given other, that is।
बताइए कहाँ पर है और आपको नहीं दिया है बता
Yes,
दीजिए,
that is।
उसी से हम लोग एसेस कर लेंगे। एक भी अवार्ड दिखाइए, कोई ऐसा अवार्ड है इसमें?
अवार्ड शायद एग्जीक्यूट हुआ है।
बताइए। साइलेंस में रहेंगे तो कैसे चलेगा? आपको खुद ही नहीं पता, एक छोटा सा चीज के लिए बोले थे रिकॉर्ड देख के रखने, ना तो कैलकुलेशन लेके आए हैं, ना एग्जिबिट्स, बिना कुछ आप आके बोल दिए कि हमको समझ में नहीं आ रहा है, यही लिखा के डिसमिस कर देते हैं कि आपको समझ में नहीं आ रहा है।
रिकॉर्ड में इट इज एडमिटेड डबल स्टोरेज है, इट इज नॉट इन डिस्प्ले।
अभी आप हमको बोले दूसरे को दिया है।
एक जैसे एग्जीबिट होता है उसमें शायद किसी का एग्जीबिट है। एग्जिबिट नहीं है, किसी का दिया हुआ एग्जिबिट नहीं है।
एग्जिबिट 7 क्या है? एग्जिबिट 7
एग्जिबिट 7 रेट चार्ट,
बस वही रेट चार्ट है।
हम बस रेट चार्ट।
Valuation chart.
देखिए लैंड एक्विजिशन में कोई भी चीज एक केस के लिए नहीं होता है ना,
नहीं नहीं, इट इज
तो वी हैव टू बी वेरी केयरफुल अबाउट।
यस, हम कैलकुलेशन पर हम नहीं कर पाए, हम 3 दिन से आई एम वेरी फेलियर।
कौन घंटा के बाद आप कहानी सुन
नहीं, पहले ही से बोल दिए कि इसमें चूंकि हम आई वाज ट्राइंग टू कांटेक्ट द लैंड एक्विजिशन जो करते हैं वहां पर कंसेप्ट पर्सन, उनसे कांटेक्ट, बट आई वाज
हम
नॉट
नहीं
एबल
इस
टू।
तरह से अलाउ करेंगे डबल
इसको
स्टोरी।
इसको एक
नहीं नहीं, डेट वेट नहीं देंगे,
मॉर्निंग
नहीं ये
में,
सब कुछ नहीं है, हो गया बहुत।
मॉर्निंग में रख दिया जाए, हम उनसे जैसा
नहीं मॉर्निंग में किस लिए रखेंगे? हाँ 45 मिनट सुनने के बाद आपसे मॉर्निंग में रखेंगे इसको? नहीं रखेंगे, आई विल नॉट जस्ट, हमको जो समझ में आएगा हम करेंगे।
एडमिटेड फैक्ट इज दैट,
एडमिटेड फैक्ट है कि डबल स्टोरीड बिल्डिंग है,
Yes.
लेकिन
And
कहाँ
admitted
से
fact
आप
is-
बोल रहे हैं कि हर एक फ्लोर का अलग से कैलकुलेशन होगा, ये आप हमको बताइए।
ये गवर्नमेंट
और
का
दूसरा बात सेम रेट से कैलकुलेशन कैसे होगा?
गवर्नमेंट का नोटिफिकेशन देखने से ही ये
कोई गवर्नमेंट का नोटिफिकेशन
ये
जो
उसी
चीज
से
आप
हो-
लेके नहीं आए हैं हम उसको कैसे हम कंसीडर करेंगे?
नोटिफिकेशन के अनुसार से ही
नहीं हो सकता ऐसा, आपके कहने से कुछ नहीं होगा ऐसा। कुछ भी मटेरियल रिकॉर्ड पे नहीं है।
एक चीज और पेज 5 खाली देख लीजिए, पेज 5 ऑफ
किसका?
द जो रिकॉर्ड है, जिसमें चार्ट जो रेफरेंस चार्ट है, उसमें जो कैलकुलेशन का किए हैं मेरा अवार्ड का बिल्डिंग का, वो खाली देख लीजिए।
पेज 5 ऑफ द चार्ट,
यस,
बताइए कौन सा
रेफरेंस
चार्ट?
चार्ट दैट आई वाज, सीरियल नंबर 5 में मेरा है रेफरेंस चार्ट में,
कहाँ है रेफरेंस चार्ट?
अवार्ड नंबर 15 का, जो बिल्डिंग का जो किए हैं।
पेज 5
यस
रविंद्र राय,
यस, सीरियल 5, उसका जो कैलकुलेशन किए,
सीरियल 5 हाँ
यस,
हाँ,
रविंद्र राय, उसका जो ऊपर 4 आदमी का जो कैलकुलेशन किया है, मेरा सीरियल 5 में किया है,
हाँ
उसमें कॉलम 21 जो है
हाँ
उसमें कैलकुलेट किया है 5,66,120
हाँ
ऑब्लिक अब 8,66,150,
हाँ
और फिर एडिशनल 15 ये जोड़ते हैं, एडिशनल 100% फिर जोड़ते हैं कॉलम 22 में, और टोटल जोड़ के मेरा जो ये बनाते हैं वो बनाते हैं 11,32,240 और फिर 16,13,000 एज पर द रेफरेंस।
अरे आपका ये सारा कुछ मिला के है।
नहीं, वो जमीन मकान का नहीं है, जमीन का नहीं है, वो सिर्फ ये अवार्ड का,
हाँ तो?
लेफ्ट साइड खाली पढ़ लिए,
हाँ फिर?
मकान का ही,
फिर?
तो उस अनुसार से भी तो मेरा 11 प्लस 16 लाख ये जोड़े हुए हैं वहां पर रेफरेंस में।
नहीं ये सब इस तरह का डिस्क्रिपेंसी हमें यहाँ पे
ये
नहीं
वो रेफरेंस वही लेटर है।
हम नहीं जानते, आपको एविडेंस से दिखाइए, ऐसे थोड़ी होगा कि आप
आप-
डॉक्यूमेंट से दिखाइएगा ऐसे।
और हमारा जो ऑब्जेक्शन है उसका कहीं डिनाई नहीं किए हैं ये कि इट इज नॉट ए मिलट बाय।
अरे भाई ये तो दिख रहा है कि इट इज नॉट ए डबल स्टोरीड बिल्डिंग, लेकिन डबल स्टोरीड बिल्डिंग का वैल्यूएशन कैसे होगा ये कौन बताएगा?
my valuation given in the objection has not
आपने
been
तो 1 करोड़ का वैल्यूएशन किया है।
has not been denied by them by
एक करोड़ रुपए दे देते
giving
हैं
any cause any reasons for that।
तो
कोई
एक-
रीजन नहीं दिए हैं कि कैसे कैलकुलेट करेंगे। उनका जो WS है इन ए क्रिप्टिक 5 पैराग्राफ का WS है, and considering और जो फाइंडिंग है by the authority वो पैरा 12 में ये करके कर दिए हैं कि it is not deluxe, it is yeah, therefore it is they have calculated, but he has not given any finding with regard to storage and per story का क्या होगा, फर्स्ट स्टोरेज का कितना होगा, ये फाइंडिंग ही नहीं है कोर्ट बिलो का. दिस इज
इस पे कोई फाइंडिंग भी नहीं है, कोई मटेरियल भी नहीं है.
मटेरियल तो एज पर ये मटेरियल है
कोई
एज पर
material
इफ
तो
इट इज
नहीं है.
एडमिटेड
हाँ?
इट इज एडमिटेड है कि रेट इवन इफ वी एक्सेप्ट इज 3082 and it is admitted also that it is a second 2 stories building.
तो सेम रेट कैसे होगा फर्स्ट फ्लोर और ग्राउंड फ्लोर का?
So, ये रेट भी नहीं डिफरेंस किए हैं. ये दिस इज माय
तो ये
कमर्शियल.
एविडेंस किसको देना था?
हम तो एविडेंस थ्रू आउट किए हैं कि मेरा 2 स्टोरेज का है. हमको कैलकुलेट हमारा कैलकुलेशन चार्ट है उसको ये डिनाई नहीं किए हैं. इनटू 2 किए हुए हैं समूह चार्ट. दे हैव नॉट
नहीं,
इनटू 2 किया हुआ है. तेरा में दिया हुआ है.
इसमें जो सबमिशन है वो जो ये WS का थोड़ा सा पढ़ देते हैं.
बताइए.
बीच से पढ़ रहे. It is further submitted that the amount has been ascertained as per the rate of non-transferable nature of the land. Accordingly, although the situation of the land and the structure thereon is beside the circular road building in the river town, and the statement made about the structure and use building is correct, but the documents available on record is not proper to ascertain the claim.
Ascertain the
Ascertain claim of the petitioner.
कौन सा पैरा पढ़ रहे हैं?
पैरा 12 में व्यूअर्स फर्स्ट पैराग्राफ की लास्ट 4 लाइन ऊपर से.
ऊपर वाला क्या है? ऊपर का लैंड वाला में नीचे मकान
पैरा
का
12 नहीं, पैरा 4. पैरा 4.
पैरा 4.
पैरा 4 में जो CO का लेटर है उसके बाद जो the amount of the compensation of the land building has been ascertained in the legal and genuine manner pursuing the land as residency non-transferable in nature and the record of right is not as
कहाँ से पढ़े थे? इंटरनल पेज क्या है ये?
internal page 18 notes.
आपके रिटन स्टेटमेंट का?
रिटन स्टेटमेंट नहीं notes इन जजमेंट में जो रिटन स्टेटमेंट का सबमिशन है वो जो हम उसको पढ़ो. पैरा 4 में पेज 18 बर्डिंग पेज 18 में पढ़ो.
पढ़िए तो.
पेज 18 में वो जो शुरू से ऊपर से पढ़.
नहीं, आप पढ़िए जहाँ से पढ़े.
It is further submitted that the amount ascertained as per the rate of the non-transferable nature of the land accordingly, although the situation of the land and the structure thereon is beside a circular road within Devgarh town, and the statement made about the structure and the use of building is correct, but documents available on record is not proper to ascertain the claim of the petitioner.
स्ट्रक्चर एंड यूज ऑफ द बिल्डिंग इज करेक्ट. मतलब डबल स्टोरी तो करेक्ट हो गया.
स्ट्रक्चर के बारे में वो करेक्ट, लेकिन वो डॉक्यूमेंट्स जो प्रॉपर.
क्या डॉक्यूमेंट? डॉक्यूमेंट लैंड का नहीं है ना. स्ट्रक्चर एंड बिल्डिंग तो करेक्ट है, यानी कि डबल स्टोरी इज करेक्ट.
यस.
ठीक है. लैंड का डॉक्यूमेंट नहीं है क्योंकि ट्रांसफरेबल नहीं है. लैंड के वैल्यू पे तो कुछ बोल ही नहीं रहे. ही इज हैप्पी विद व्हाटएवर
they
कंपनसेशन.
have given the enhance. It has already been enhanced.
FA number 88 of 2024. This appeal has been filed under section 74 of Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act of 2012. 2013, the Learned Counsel for the Appealant has submitted that the appellant is only aggrieved by quantum of compensation as discussed in paragraph 12 of the impugned judgment, to the extent that there has been no payment of compensation with respect to the first floor of the construction,
Award number 14.
which relates to award number 14. He has further submitted that the area of construction as 382.5, which is the area of construction over 382.5 square feet of land is not in dispute, and so far as the rate is concerned, that same has been taken as rupees 3051 per square feet, which was as per the rate chart. But while computing the amount, only the area of the land has been taken into consideration, and the construction over the first floor has not been taken into consideration. He submits that he has placed the plaint and the written statement and has submitted that the construction nature and the extent of construction is not in dispute. The Learned Counsel has submitted that on account of this aspect of the matter, the quantum of compensation with respect to the building ought to have been twice, and instead of 11,67,007 as computed by multiplying area of constructed area on the land, that is 382.5 square feet, by the rate 3051, he submits that equivalent amount should be given for the first floor of the construction, and the award be enhanced. The Learned Counsel, appearing on behalf of the respondents, has submitted that the land was non-transferable, and as has come in the finding and has referred to paragraph 4 of the impugned judgment, wherein it has been recorded that the structure and use of the building was correct, but the documents made available on record was not proper to ascertain the claim of the appellant. The Learned Counsel has also submitted that in view of the stand taken by the respondents in their written statement and submissions made before the learned court, the amount of compensation with respect to the structure in connection with which the appellant has a grievance does not call for any interference. At this, the learned counsel for the appellant has submitted that in the objection filed by the appellant, it was clearly mentioned that there is a double-storied pakka building over the property, and the measuring area of the acquired land was mentioned as 382.5 square feet. And the rate at which the appellant claimed was at the rate of rupees 5302 square feet per square feet. And had also mentioned that as per the market value, the rate for single storied comes to rupees, the amount of the compensation for single storied comes to rupees 20,28,015, and for double storied it would be twice, that is 40,56,030. Such statement was made in paragraph 2 within bracket D within bracket Roman 5. It was further case of the appellant before the court that the calculation was done without granting them an opportunity of hearing, and the amount of rupees 11,32,240 was awarded instead of 40,56,030 for the first and the second floor. He submits that in response to such statement, the reply was evasive, and it was never the case of the respondent that for the purposes of double-storied building, twice the amount payable for ground floor is to be paid. यही है ना आपका? Denial तो नहीं है कहीं इनका?
नहीं कहीं नहीं।
Considering the nature of dispute as argued by the learned counsel for the appellants, this court is of the view that the point of determination in the present case is as to whether the appellant was entitled for compensation for the ground floor as well as first floor, and consequently the for ground floor as well as first floor. or the compensation would be confined to the square feet area of the land and the rate chart and the rate given in the rate chart. After hearing the learned counsel for the parties, this court finds that the objector had clearly taken a plea that the constructed area was 382.5 square feet, and for first floor it would come to rupees 20,28,051 at the rate of rupees 5302 per square feet, and for the second floor equivalent amount would be payable, and consequently the total amount would be 40,56,030 for the double story building, and only an amount of rupees 11,32,240 was awarded. From the perusal of the written statement which was filed before the learned court, the claim of the appellant that the appellant was entitled to compensation for first floor and equivalent compensation even for the second floor has not been disputed. The area of construction to the extent of 382.5 is also not in dispute. This court also finds that the learned court, by considering the materials on record, this court also finds that the learned court has also recorded in paragraph 12 with respect to the area of construction and taken the same as 382.5 square feet, but the rate has been taken as 3051, taking the building with taking the rate for building with RCC roof commercial instead of
deluxe commercial.
deluxe building / apartment.
Commercial.
And has calculated the compensation at the rate of 11,67,007. But the award is completely silent with respect to the point as to whether the appellant would be entitled for equivalent compensation with respect to the first floor. No material from the records has been pointed out by the learned counsel for the respondent to with respect to the claim of the appellant that equivalent compensation was payable even for the first floor. The plaint and the written statement, upon perusal of the plaint and the written statement, this court plainly, the objection and the written statement filed by the state, this court finds that the claim of the appellant that for each floor separate calculation has to be made was not denied in the written statement. In view of the aforesaid facts and circumstances, this court is of the view that the learned court has failed to take into consideration that the building was admittedly of 2 floors and therefore the compensation having been awarded only for the ground floor, that is area of 382.5 square feet, has been given, but the construction in connection with the first floor has been totally omitted. Consequently, the compensation with respect to the building and in relating to award number 14 is enhanced to 3051 into 382.5, इसको ब्रैकेट में डालेंगे, into 2, that is 1167.007
It will come around 23,
into 2,
34, 23, 34014.
23,34014. And the appellant would also be entitled to interest.
So lithium also.
No, the entire amount under award number 14 will be calculated on the basis of the aforesaid amount, enhanced amount of rupees 22. तो automatic calculation
Or
हो
it
जाएगा।
automatically is lithium.
सारा कुछ
Yes.
मतलब 11,67,007 की बजाय वो amount है। This appeal is accordingly allowed with the aforesaid modification of the award. Office to prepare a decree. Decree बनेगा ना यहाँ? हाँ, dispose. In terms of aforesaid modification of the award.
From trade list, item 5, first appeal 3 of 2023.
I have prepared the whole written submission where I have included the judgments, relevant paras as well, and this is
Yes.
the compilation of judgments. I have prepared it with the list of table.
आपका भी है?
But I'll include more.
नहीं ऐसा improvement का
नहीं,
कोई
आप-
scope मतलब there is no input जो है वो दे दो।
जी है तो दे। इसमें I have formulated 4 questions and दे देंगे। According to me, there are 4 questions that are involved. The first one is whether the suit was barred in terms of section 69(2) of the Indian Partnership Act. Whether the suit is barred by section 5, read with section 8 of the Arbitration and Conciliation Act. Whether the plaintiffs have been able to prove allegations of fraud against Samir Kumar Yadav. Whether the plaintiff could have claimed a sum of rupees 13 lakh on behalf of Ramdar Singh. So primarily, according to me, these are the questions that are required to be answered. In my note, I have answered 3 questions. I have not answered the second one. So second one, I am still searching for some judgment, which I have got 2 Supreme Court judgment, but some more time. Because Your Lordship, whatever ultimate is the judgment, Your Lordship, that would have an effect. Therefore, I was paying. Otherwise, I could have summarily included my argument. There are 2 judgments on which I am relying on, where the Honorable Supreme Court has said that what would be the impact of cases where there is an arbitration agreement between the parties. Then, if the conditions as prescribed under Section 8 are fulfilled, then civil court has has to refer the parties to arbitration. It does not, it cannot retain the matter whatsoever. So, but the conditions have to be fulfilled. But there are two judgments on which I'll be relying. But your Lordship, I'll only pray that your Lordship may fix on Monday.
बस हो गया जितना रिसर्च आप कर लो
On Monday, I will pray.
जजमेंट तो आप लोग ऐसे भी हमको दे सकते हैं उसके लिए और कोई जरूरत नहीं दिस इज
नहीं।
एब्सोल्युटली प्योर
हाँ,
क्वेश्चन
ठीक
ऑफ
है,
लॉ
pure
इसमें
question.
कुछ भी नहीं है
Pure,
ऐसा।
pure question.
अगर आपको कुछ जजमेंट मिले तो उनको दे दीजिए आप कोर्ट में
ठीक,
दे
ठीक,
दीजिए उसमें दिक्कत
ठीक,
नहीं
ठीक।
लेकिन इस चीज को अननेसेसरी ना
ठीक।
बार बार इसको पोस्टपोन करना ठीक नहीं है
ठीक।
इट इज एब्सोल्युटली प्योर क्वेश्चन
ठीक है,
ऑफ लॉ सेक्शन 8 का पिटीशन नहीं फाइल हुआ ऑब्जेक्शन फाइल हुआ रिटन स्टेटमेंट में एट द थ्रेशोल्ड
Yes. Written
ऐसा नहीं है
statement-
कि बाद में कुछ आया
हाँ, written statement में it is there,
हाँ।
and section 8 only mandates that at the time of filing of first defense, written statement was the defense itself.
Yes.
So if it contained that objection,
that
then
should be sufficient according to
that was
but according to them
an application, separate application was required, where I was required to make a specific plea to refer to the parties to arbitration. This is their content. So according to me, if it was there in the first defense itself, then that was sufficient.
with respect to the other points it is covered
Yes.
complete
Yes.
kindly place it एक बार इसको क्विक रीडिंग करें
It is covered, but इसको सिर्फ I've just dictated and this is the copy I have got. Therefore I was.
आपके पास नहीं है
नहीं है.
आप तो
है
पढ़िए
लेकिन इसमें थोड़ा टाइपिंग एरर होगा.
कोई
which
बात
you are
नहीं
अच्छे
हम
में
करेक्शन
ignore.
कर लेंगे
Yes.
जहाँ
May I
है
read-
बता दीजिएगा हाँ
May I
एक बार
read
पढ़
the
लीजिए
entire because-
देखिए बहुत इंपॉर्टेंट इशू
No,
है
I'll read out
एक
the entire.
अनरजिस्टर्ड पार्टनरशिप डीड की कहानी है
Yes.
तो वो एक इम्पोर्टेंट टेक्निकल इशू है एक टेक्निकल इशू या आर्बिट्रेशन है
Yes.
these are very technical points which are required to be answered
Yes. I've answered.
पढ़िए इसको
Question number 1 and 3. One, your Lordship, is whether the suit was barred in terms of section 69 of the Indian Partnership Act, and the 3 is whether the plaintiffs have been able to prove the allegations of fraud against Samir Kumar Yadav. Why these are interconnected, I have stated here. Question number 1 and 3 are interconnected and therefore the same is being taken together. It is the case of the plaintiff that the plaintiffs had executed a deed of partnership with Samir Kumar Yadav, which was not registered before the registrar of firms in terms of section 58 and 59 of the Indian Partnership Act. Rather, they have said that it was registered with the district surveyor. Section 69 of the Indian Partnership Act, 1932, very clearly mentions that no suit to enforce a right arising from a contract or conferred by this act shall be instituted in any court by or on behalf of any person alleged to be or would have been a partner in the firm unless the firm is a registered and the person showing in or has been shown as a partner in the firm. Thus, if the said section 69 is applied to the facts of the incident case, it shall transpire that the plaintiffs who have not been shown in the register of firm as partner in the firm, as the firm itself was not registered in terms of section 58 and 59 of Partnership Act 1932, the plaintiffs cannot file a suit to enforce a right arising from a contract, that is a partnership agreement, particularly against Samir Kumar Yadav or his legal heir. Although the plaintiffs have tried to make out a case that because Samir Kumar Yadav had defrauded them by taking the suit amount by projecting a very rosy picture before them, the said power under section 69 of so and so would not be applicable. Thus, for the purpose of getting over the bar under this section 69 of Indian Partnership Act 1932, the plaintiffs are required to prove that Samir Kumar Yadav had committed fraud upon them, and it is only if they were able to establish that Samir Kumar Yadav had committed fraud, their suit would be maintainable. Therefore, it is essential to see as to whether the plaintiffs had actually been able to prove as to whether Samir Kumar Yadav committed fraud upon them or not. From the perusal of statement made in the plaint, the following are important points to be
You
taken
just
note of.
if they are able to prove that they have committed fraud, according to you, the suit was maintainable?
Yes, yes. If they were able to prove that fraud was committed, because their whole allegation is that it was before the signing of the agreement itself, Samir Kumar Yadav had presented a very rosy picture, and therefore obviously the signing of the agreement also was a part of the entire fraud committed by Samir Kumar Yadav. This is their stand. So if they are able to prove that Samir Kumar Yadav had committed fraud, then the Honorable Supreme Court has said, then the clause of the agreement also is a part of the partnership deed, which is by during the commission of the fraud. But then there is a rider in the Supreme Court judgment. So the Honorable Court then says, mere allegation of fraud would not be sufficient.
Which is that judgment?
So, yes, this is. Therefore, your Lordship has to see as to whether it goes to the root of the entire case, or that means the arbitration agreement itself. Simple
This
allegation
is in
of
connection with fraud in the matter of arbitration agreement.
yes,
But I am asking fraud in the case of a partnership. This I am aware of.
yes,
That if there is an arbitration clause and if there is a basic element, fraud can be adjudicated even by the arbitrator.
yes, yes.
There is no bar.
No.
But the point is, what is the nature of fraud, whether there is a criminality involved, and what is the nature of fraud is to be examined. Merely because somebody says
No, no.
fraud,
There is
arbitration is not
absolutely
ousted.
no, absolutely not. Only one thing. No, I'll come to that judgment also, where the Honorable Court has said that if the signing of the agreement itself was a part of the entire fraud itself, so therefore there would not be any arbitration agreement also. So that is the extent of fraud that has to be pleaded and proved, that the arbitration agreement was a part of an agreement which was the parties had
Whenever
signed
Section
by-
8 is filed, there is no question of pleading and proving. When Section 8 application is filed, that the suit is not maintainable, then the court will scrutinize what? The court will at best scrutinize whether the agreement by itself has been alleged to be a fraud, then every clause therein is fraudulent.
Yes, yes.
Right?
Yes,
If
that
the entering into the agreement is not fraudulent, then under such circumstances, not fraudulent, it means it has not been executed and somebody else has
Yes.
signed it. There's so many kind of fraud which is possible at the time of entering into the agreement. Those cases, I think, are referable to arbitration.
Otherwise, all cases are referable to arbitration. Only exceptional cases where the entire contract itself is vitiated
As long as it is between the party
between the parties.
and fraud is not touching upon any kind of public
public
domain.
Yes, exactly. This
Therefore, under such circumstances, it can be
is,
identified.
yes, if it does not affect the general.
Okay. Right. Then,
Then
what about partition? The same principle will apply with regard to the bar in connection with an unregistered partnership form.
because if it is their whole case, your Lordship, is that they admit that they are parties to a partnership deal. They signed everything, admit, but their whole contention is based upon the fact that Samir Kumar Yadav had committed fraud, had presented a very rosy picture, and thereby induced Samir Kumar Yadav to enter to the plaintiff to enter into a partnership and then to invest certain amount. Their entire case is that. So therefore they say that there was actually no partnership. That is their contention. Now, for this, if therefore Samir, it was absolutely necessary to establish that Samir Kumar Yadav and to prove that Samir Kumar Yadav had committed fraud. And what is their allegation? They simply say, I've quoted all these things. Your Lordship may allow me to read
Yes,
this?
yes, please.
Yes. Your Lordship may, from the perusal of statement made in the claim, the following are important points to be taken note of. Before entering into deed of partnership, these are statements made in the claim. Into deed of partnership, Samir Kumar Yadav had told the plaintiff about the land development business and had also showed them about 40 acres of vast tract. This is vast tract. Vast tract of land pertaining to Khata number 96, plot number 1327, and other plots of the same Khata of Mauja so and so. Therefore, Samir Kumar Yadav, before entering into partnership with plaintiff, had openly disclosed. This is my observation. Therefore, Samir Kumar Yadav, before entering into partnership with the plaintiff, had openly disclosed the land and had showed the plaintiff where it was situated. It is only thereafter the plaintiff had entered into partnership with Samir Kumar Yadav on 29/11/2012. According to the statement made in the plaint as well as evidences adduced on behalf of the plaintiff, no date whatsoever was mentioned as and when the plaintiffs came to know about the alleged fraud. The partnership agreement was entered into on 29/11/2012 and Samir Kumar Yadav died on 14/5/2014, and according to the plaintiff's own case,
ये डेट सही है?
pardon,
2012 होगा ना?
12 है, वो 14 गलती से.
हाँ.
29/11/2012 and Samir Kumar Yadav died on 14/5/2014, and according to the plaintiff's own case, the plaintiff came to know about the fraud and when they found out that actually no land for land development business was ever purchased by Samir Kumar Yadav and actually no partnership business was started, as nothing invested by Samir Kumar Yadav in the business, and he had taken 29 lakh from the plaintiff by playing fraud upon them. The plaintiffs have further stated that plaintiffs started making demand of refund of the amount, whereafter they issued, they means Samir Kumar Yadav. Samir Kumar Yadav issued 3 checks which were not encashed on the request of Samir Kumar Yadav. Then, Rama Shankar Rai, the plaintiff, Rama Shankar Rai, who is plaintiff number 1, was examined as PW1, who in para 42 and 53 in cross-examination has stated that he did not give any written notice. Few typing errors.
कोई बात नहीं.
He did not give any written notice to Samir Kumar Yadav, and he further stated that he had verbally told Samir Kumar Yadav, but he did not give any written notice to him. Order 6/4 very clearly stipulates that any person who is alleging fraud has to give particulars of fraud. In the instant case, the plaintiffs have made general allegations of fraud and have not been able to prove or furnish fraud as required under the said provision. The plaintiffs have failed to furnish particulars of fraud, but on the other hand, the facts of the instant case would go to show that even according to the plaintiff's case, they all were acting in furtherance of the partnership deed as partners. The following would go to show that they all along with Samir Kumar Yadav were acting in furtherance of the partnership deed executed by and between them. According to their own statement made in the plaint, when the plaintiffs had financial crunch, that means plaintiffs approached pro forma defendant Sri Ramdas Singh to provide monetary help to them for the development of business, and the said pro forma defendant had agreed to pay the said amount to the plaintiff so that the plaintiff may give the said amount to Samir Kumar Yadav for smooth running of the business. It is at their request, Mr. Ramdas Singh, the pro forma defendant, paid a sum of rupees 13 lakh to the plaintiff for investment in the partnership business, and all the investment of rupees 13 lakh of Mr. Ramdas Singh was shown as invested by the plaintiffs in the partnership business. All this is statement from the plaintiff itself which I made. Thus, at best, any amount which was paid by Mr. Ramdas Singh or plaintiff were, according to the plaintiff's own case, invested in the partnership business, and according to the plaintiff's own case, Mr. Ramdas Singh, pro forma defendant, had, after making payment of rupees 8 lakh, demanded proof of his payment to the plaintiff, and it is the plaintiff who executed money receipt dated so and so, showing this said amount was being given in partnership business of the plaintiff, and in the said money receipt, Samir Kumar Yadav only signed as a witness. Thus, the money receipt dated so and so was given by the plaintiff to Mr. Ramdas Singh, and Samir Kumar Yadav had only signed as a witness. Thereafter, I have quoted to Supreme Court judgment, Your Lordship, where fraud, what is the nature of fraud, that has to be seen. Then, if the law laid down by Honorable Supreme Court is applied, it can be very clearly seen that the plaintiffs have failed to plead as well as prove for fraud on the part of Samir Kumar Yadav, and no details of fraud were ever disclosed or even evidence regarding the fraud was ever given. Therefore, the plaintiffs have thoroughly failed to prove the allegations of fraud committed by Samir Kumar Yadav. Once it is held that the plaintiffs had failed to prove the fraud committed by Samir Kumar Yadav, only logical sequence would be that the plaintiffs, according to their own case, had entered into the partnership business with Samir Kumar Yadav, and they had invested the said partnership business as partner of the firm, and therefore whatever transactions took place between the three partners, the other partners could not have diverted the fact of investment made in the partnership business as personal liability of Samir Kumar Yadav. Therefore, the instant suit was clearly barred in terms of Section 69 of the Indian Partnership Act, as the plaintiffs were partners of unregistered partnership firm, and they could not have showed any another partner of the same unregistered, and they could not have sued. They could not have sued another partner of the same unregistered firm. The only exception was the plaintiffs, being partners of the unregistered firm, could have sought for dissolution of the firm or for accounts of the dissolved firm, or any right or power to realize the property of a dissolved firm. The plaintiffs have in fact not filed any suit for dissolution of the accounts of the firm, and therefore they are not covered by the exception carried out mentioned in Section 69 of the Partnership Act. The suit is thus barred in terms of Section 69(1) of the Partnership Act. Now, question number 4 is whether the plaintiff could have claimed a sum of rupees 13 lakh on behalf of Ramdas Singh, that is pro forma defendant. From the statement made in the plaint itself transpires that it is the plaintiff who are facing financial crime, and therefore they had approached the pro forma defendant, Sri Ramdas Singh, to provide monetary help to them for the development of business, and that the pro forma defendant had agreed to pay the said amount to the plaintiff so that the plaintiff may give the said required amount to Samir Kumar Yadav for smooth running of the business. It is the plaintiff who had taken 13 lakh from the pro forma defendant, namely Ramdas Singh, and it is the plaintiff who had executed money receipt dated 2/2013, and Samir Kumar Yadav had only signed as a witness. On the contrary, the defendant number 3, Sri Ramdas Singh, had stated that he paid total sum of 13 lakh to the plaintiff as well as defendant number 1 and 2, and therefore Sri Ramdas Singh had reserved the right to file a counterclaim against the plaintiff as well as defendant number 1 and 2. From the statement made in the counterclaim of defendant number 3, it was absolutely clear that it is the defendant number 3 who has yet to file a counterclaim against the plaintiff as well as defendant number 1 and 2, and according to pro forma defendant number 3, the plaintiff were also liable to pay this said amount, and it was not Samir Kumar Yadav who alone was responsible, and therefore the defendant number 3 sought to file a counterclaim against the plaintiffs also. The plaintiffs could not have claimed a sum of 13 lakh, which is said to have been given by Sir Ramdas Singh, more so in view of the fact that it is the plaintiff who had taken money from Ramdas Singh and had paid the same to Samir Kumar Yadav. Although the defendant number 3 has also stated that he shall file a counterclaim against so and so, plaintiff and defendant number 1 and 2 respectively, who has in fact never filed any counterclaim, and therefore the said amount of rupees so and so would not have been claimed by plaintiff from the defendant number 1 and 2 in order to pay it to us. So these are my submissions. And strangely, Your Lordship, nothing against my learned friend. It is nothing personal. All the 3 respondents he is representing.
Well,
Therefore, that clearly shows that the original plaintiffs as well as defendant number 3, they were, although the defendant number 3 had actually said that he would be filing a counter claim against the plaintiffs as well as defendant number 1 and 2, but actually they were together.
इस कंडक्ट के कारण हम आपका केस नहीं डिसाइड कर
नहीं, that is absolutely, they are sailing in the same boat, and right throughout these are my allegations. It is not coming out of blue.
मुझे आज तक ये नहीं समझ आया इस record में कि defendant number 3 why didn't he joined as a co-plaintiff?
नहीं समझ में आया, and your lordship
Why didn't he join as a co-plaintiff?
Now your lordship must test the impugned judgment on as if your lordship this is coming for the first time, and your lordship has to decide the entire suit itself, original suit itself. Now whether a person who is a pro forma defendant, he does not come forward to be joined as a plaintiff, or because he is the one, actually what his grievance was against both the plaintiff as well as Samir Kumar Yadav, because he had not advanced solely to Samir Kumar Yadav. So therefore, without impleading the 2 plaintiffs as well as Samir Kumar Yadav, he could not have made any claim whatsoever. So his suit would not have been.
चलिए ठीक है, आपको क्या बोलना है? ये आपकी तरफ से है?
no, that's it.
Before he starts, Your Lordship, last judgment which I am relying on, recent judgment of Honorable Supreme Court, where what would be the effect of suit in an unregistered partnership firm, that Your Lordship may see, I'll only point out 2 paragraphs. Para 2, Your Lordship may see, it appears from the material on record that the petitioner's hearing, original plaintiffs instituted original suit number so and so, praying therein the following relief, and the second page is for recovery of rupees 30 lakh only from the defendant. And para 3, in the suit proceeding, the issue as regards maintainability of the suit was raised on the ground that a partner of an unregistered partnership firm could not have filed a suit for recovery of money being hit by section 69 of the Indian Partnership Act so and so. And then the High Court in para 6, Your Lordship, the High Court took a view that the suit is not maintainable being hit by section 69 of the Partnership Act, the High Court in its impugned judgment while allowing the revision so and so observed as follows. Now, conclusion is at page para 8. It is evident from the reading of subsection 1 and 2 of the section 69 that it assumes a mandatory character. Section 69(1) prohibits suit amongst the partners of an unregistered partnership firm for the enforcement of a right either arising from a contract or conferred by the Act unless the suit among the partners is in the nature of dissolution of a partnership firm or for rendition of account. Section 69(2) prohibits, now section 69(2) is different, where unregistered partnership firm files a suit against outsider. So this is also prohibited. Section 69(2) prohibits the institution of a suit by an unregistered firm against a third person or for enforcement of a right arising from a contract. As a consequence, a suit filed by unregistered partnership firm and all the proceedings arising thereunder which fall within the ambit of section 69 would be without jurisdiction. This court in said so and so has categorically held that section 69 is mandatory character and a suit instituted by a plaintiff in respect of a right which was vested in him by virtue of a contract and entered into in his capacity as a partner of a partnership firm would be void if such a firm was unregistered. Then it has been quoted, and then your Lordship may see para 15, last 3 lines, that is the conclusion. It is clear as a noonday that the present suit has not been instituted by on behalf of a firm against the third person so as to fall under 69(2). The petitioners have also not filed and so and so. Hence, the rigors of section 69(1) would apply on such a suit, and the partnership firm being unregistered would prevent the petitioners from filing a bare suit for recovery of money from the respondent. And then the ultimate conclusion was
Unless the suit could have been maintainable if it was for dissolution.
yes, absolutely, because
But otherwise, the transaction, interstate, or enforcement of any right arising out of partnership, according to you, the suit was not made.
no, not maintainable. And their whole case is that it is only because of partnership deed they gave money. Time and again they have made this statement.
So let him say. Yes.
So I will start from para 5 minutes. My very late terms. The instant suit is a case of civil liability and the claim of the respondent plaintiff is a common law right. It is submitted that a case of civil liability is made out against the appellant defendants as Samir Kumar Yadav disease fraudulently induced the respondents plaintiffs into investing rupees 29 lakh by falsely claiming to start a land development project at Moja Bhawanipur that never existed. The Honorable Patna High Court in Ram Narayan Renu versus the state of Bihar had observed as follows. The reading highlighted closer is there, brothers. The right to recover money lost to plaintiff by the reason of an action or inaction on the part of the defendant is a common law right. 7 minutes. Section 609 CPC only deals with jurisdiction of the court to try suit. However, for instituting a suit, 2 prerequisites must be fulfilled. The first requirement, which is fundamental to the maintainability of civil suit, is the existence of cause of action. The other prerequisite for instituting a suit is that the plaintiff must have right to sue. As far as right to sue is concerned, it is a common law right or inherent right. Unlike appeal, right to sue need not be provided and has generally not been provided by any statute. Certain statutory provisions only recognize the right of agreed party to institute suit. In Gangabai versus Vijayaram, it has been held as follows. There is an inherent right in every person to bring a suit of civil nature, and unless the suit is barred by statute, one may at one's peril bring a suit of one's choice. It is no answer to a suit, however frivolous the claim, that the law confers no such right to sue. A suit for its maintainability requires no authority of law, and it is enough that no statute bars the suit. In Shiv Kumar Chadha vs. Municipal Corporation of Delhi, it was held that under classical law the position is that where there is a right, there is a remedy. The position regarding special acts creating rights and liabilities was also clarified in same para 11, which is quoted below. In the olden days, the source of most of the rights and liabilities could be traced to common law. Then statutory enactments were few. Even such enactments only created rights or liabilities but seldom provided forums for remedies. The result was that only that any person having a grievance that he had been wronged or his right has been affected could approach the ordinary civil court on the principle of law that where there is a right, there is a remedy, ubi just ibi remedium. As no internal remedy has been provided in different statutes creating rights or liabilities, the ordinary civil courts have to examine grievances in light of different statutes. With the concept of welfare state, it was realized that enactments creating liabilities in respect of payment of taxes, obligations after vesting of states, and conferring right on the class of citizens should be complete code by themselves. With that object in view, forums were created under the Act themselves where grievance could be entertained on behalf of the person aggrieved. Provisions were also made for appeals and revision to higher authorities. In this regard, reference may also be made to second principles mentioned in para 23 of Premier Automobile versus KS Valke, which has also been quoted in Rajasthan SRTC versus BM Bairwa, where along with common law, general law was also mentioned. If a dispute is an industrial dispute arising out of a right or a liability under the general or common law and not under the Act, the jurisdiction of the civil court is alternative, leaving it to the election of the suitor concerned to choose his remedy for the relief which is competent to be granted in a particular remedy. In the present suit, a perusal of Exhibit 2, 2/1 and 2/2 would make it apparent that Sameer Kumar Yadav in his individual capacity took money from the plaintiffs for investing in a land development project. However, as per para 7 of the plaintiff came to know an inquiry that no land for land development business was ever purchased by Sameer Kumar Yadav, and in order to deceive the plaintiffs, Sameer Kumar Yadav executed a deed of partnership dated 29/11/2012, Exhibit 1. But after receiving money from the plaintiffs, both directly and through the pro forma defendant number 3, Sameer Kumar Yadav played fraud upon the plaintiffs and diverted the funds for his personal use.
Please hold. Is there any evidence of personal use? Diversion?
Because
for
when the-
personal. Is there any evidence, any iota of evidence that he diverted this money for personal use? And
Because
where did he divert?
the reason, my lords, this is as per I have dealt with it afterwards, my lords, that as per the Exhibit 1, Clause 6, account of the firm was to be opened, and this money could have been put in the account.
Don't dodge my question.
Well,
If you dodge my question, I take an impression that you don't have an answer. I want to know, is there any finding or is there any material that Sameer Kumar Yadav had diverted the amount and had invested at such and such place?
No, there is no such specific evidence.
There is no such evidence. Admittedly, the suit was filed after he was dead,
My lords,
and you are alleging fraud against him.
my lords,
Against a dead person, you are alleging fraud,
my lords.
right? And there is no evidence that it was diverted for any other purpose. No such evidence.
It is implied from the fact that it
No,
didn't
no,
deposit
neither in
account
the
of the firm.
not implied. Neither in the pleading. You see, in a case where you are alleging fraud, and when you say that it has been diverted
No, sir,
for own use, then you have to show something. A mere statement
Ma'am,
without
sir,
anything
I've
more
read-
in the plaint
Ma'am, sir,
and without anything in the evidence.
Once I have raised a specific issue on that, I have answered that.
Okay.
That I will come for. Thus, the entire money was taken by Sameer Kumar Yadav. My lords, yeah, thereafter.
Yes.
It is pertinent to mention that although as per clause 6 of the deed of partnership dated 29/11/2012, it was mandatory to open a bank account in the name of firm in question, no such account was opened by Sameer Kumar Yadav. Thus, the entire money was taken by Sameer Kumar Yadav in his personal capacity, as evident from para 43 of cross examination of plaintiff number 1, para 2D of written statement filed by defendant number 3. The same fact is also evident from the perusal of Exhibit 3, 3/1 and 3/2, by which Sameer Kumar Yadav in his personal capacity had issued 3 post-dated checks in the name of plaintiff number 1, when the plaintiffs, after discovery of fraud by Sameer Kumar Yadav, demanded the amount of rupees 29 lakhs paid to him. As such, the respondent plaintiffs have a common law right to recover their lost money from Sameer Kumar Yadav in his personal capacity. Of the man with respect to the second.
If Sameer Kumar Yadav had taken money in his personal capacity, why is there so much of story about the partnership firm?
Because
You are taking a contradictory point. On the one hand, you say that there was a partnership firm, you entered into the partnership firm, and defendant number 3 invested, gave you money because you had to give it to the partnership firm. You had already given some money to the partnership firm, right? There is so much of story about the partnership firm. If it was a simple transaction in personal capacity, as you have stated here, then under such circumstances, what was the need to bring so much of story about the partnership firm?
But it is just to show that why I initially paid money to him. It is just to establish the background that why this money the money was to be pulled in the partnership account. I had to invest only a particular 7,05,000 rupees, and this amount could have been invested had the firm been named, formed an account could have been opened, and all this Sameer Kumar Yadav was there from the very beginning. He was working on a project, on a land project. He wanted money. He approached us to become a partner and get share of something in that particular project. Thereafter, because of that, we entered into an agreement. He didn't give any name to that particular partnership deed. He didn't open a bank account, took money from us, and never used that money in
You
that.
gave that money yourself in his name for being used in the partnership firm.
But-
Now you say that he did not open an
Because
account.
even if
By that time you were already partners,
we were partners,
right?
We were
But when a bank account was to be opened,
Well-
then you were also equally liable to open the bank account? Or it was to be opened only by Sameer Kumar Yadav?
But Sameer Kumar Yadav was the part who.
Were you also responsible for opening the bank account? Yes or no?
As per clause 6, there is no specific thing that.
Therefore, everybody was. Therefore, in a case, you see, the entire issue is because of the reason that yes, there was money transaction. There is no doubt. The money, but what was this money utilized for would have come upfront only when there was a suit for accounts. Because the accounts would have revealed many things. But the suit was not filed for accounts. What is the consequence? This particular money remains outside the entire partnership business, and there is already a partnership business. By virtue of death of Sameer Kumar Yadav, the partnership has not dissolved.
Well, there is one thing. As per the
आपको नहीं लग रहा
partnership.
थोड़ा बहुत स्मार्टली इस काम को किया गया, बहुत सोच समझ के किया गया है. इस तरह के सूट को बहुत सोच समझ के बनाया गया. किसका पोजीशन कहाँ पर होगा, डिफेंडेंट नंबर 3 का पैसा प्लेंटिफ नंबर 1 एंड 2 सूट फाइल करके रियलाइज करेंगे, ये कहते हुए कि डिफेंडेंट नंबर 3 ने पैसा दिया था. अब पैसा चला जाएगा प्लेंटिफ नंबर 1 एंड 2 के पास, और डिफेंडेंट नंबर 3 के जिसका पैसा उसके पास तो जाएगा ही नहीं.
He has his right to recover it from us. There is an exhibit A.
वो तो बाहर हो गया अब तक. He never said that I should be transposed as a plaintiff because
No,
it is my money which is involved.
Because in the written statement also, his case is that he will recover it from us, from our sale.
ये डिजाइन नहीं समझ आ रहा. Why did he not join as a co-plaintiff?
Interesting. Now, whether he is arguing on behalf of plaintiff
हाँ,
or
किसके घर से बहस कर रहे हैं ये बताइए.
No.
That's on behalf of the
This-
plaintiffs.
Plaintiffs.
Unless there will be a specific query with respect to the performer defendant.
Should I say that you have given up
Madam,
the pro forma respondent?
Madam, being a counsel of performer defendant number 3, madam, I just said that I will support the case of the plaintiff now. I have also said that on the written statement. I support the case of the plaintiff. That was, I pleaded that the case of the plaintiff should be allowed. So I support it now also. Whatever is being argued on behalf of the plaintiff number 1 and 2, the performer defendant supports it. The next is the bar under section 69(2) of the Indian Partnership Act does not apply while enforcing a common law right. The appellant defendant argued that the instant suit is barred under section 69(2) of the Indian Partnership Act as the partnership fund was unregistered. It is submitted that the learned court below has rightly held that since no actual business was conducted and the suit was based on fraud, the bar under section 69(2) does not apply. It is to be noted that section 69(2) of the Act bars only the enforcement of those rights that arises from contract. Number 2, from Partnership Act. In the instant case, the plaintiff had not filed the suit in the capacity of partner, nor have they made the firm as a defendant in the suit. In fact, the suit was filed for recovery of money that was fraudulently taken by Sameer Kumar Yadav in his personal capacity. Further, section 69(1) of the Act bars enforcement of right by or on behalf of a person suing as a partner and against the person who has been a partner. Thus, the very object of 69(1) is that if a person intends to take the benefit of Partnership Act, then he has to comply with the mandatory requirement of registration under section 59 of the Act. It is submitted that the plaintiff have not filed this suit in the capacity of partner, nor have they sued Sameer Kumar Yadav as a partner of the partnership firm. Thus, the common law right of the plaintiff to recover money fraudulently taken by Sameer Kumar Yadav cannot be taken by virtue of section 69 of the Act. For further clarification, the judgment of Honorable High Court of Madras in S. Prakash Chand versus Sa Harachand and others can be relied upon wherein it is absorbed as under. In page 9, the highlighted portion may only be read. Page 9. 14. Quoted para 14 melons. Admittedly, in this case, the suit is not for enforcement of any right arising out of contract entered into by or on behalf of the plaintiff's firm with the defendant in the course of business transaction. Moreover, section 69(2) does not bar a suit to enforce a common law right, even if the firm is unregistered on the date of suit. Hence, the suit is not barred by section 69(2) of the Partnership Act. With the result, all the above substantial question of law are answered in the favor of the respondents. The very object and purpose of disability imposed on an unregistered firm would also become clear from the judgment of the Honorable Supreme Court in Safe Developers through its partner Sunil Bhai Soma Bhai Ajmeri versus Aksharay Developers and others. wherein the Honorable Court in Para 20 clarified the nature of suits filed by an unregistered firm, which will not be barred under Section 69(2) of Partnership Act. Para 20 is quoted here and below. To put it differently, the relevant principles, when applied to the facts of the present case, leave nothing to doubt that the transaction in question was not the one entered into by the plaintiff firm during the course of business, and it had been an independent transaction of sale of the firm's share in the suit property to the contesting defendant. The bar of Section 69(2) is not attracted in relation to the said sale transaction. Moreover, the subject suit cannot be said to be one for enforcement of right arising from a contract. Rather, the subject suit is clearly the one where the plaintiff seeks common law remedies with the allegation of fraud and misrepresentation, as also of the statutory rights of injunction and declaration in terms of provision of a specific relief act, as also the Transfer of Property Act 1882. Therefore, the bar of Section 69(2) of the Act does not apply in the present case. Thus, the instant suit cannot be said to be one for enforcement of rights arising out of a contract. Rather, the suit is clearly the one where the plaintiffs have sought common law remedies with the allegation of fraud. Now, my lords, bar under Section 5 of the Arbitration and Conciliation Act is not applicable with respect
That
to that.
already submitted. इसका LCR का रिकॉर्ड सेट कहाँ है? इतना ही है LCR?
Well,
इतना ही है?
जी
thereafter, my lords, page 12.
Yes. Yes.
Page 12, my lords. The suit is not barred under Order 6, Rule 4 CPC.
Yes, please.
Order 6, Rule 4 CPC reads as under. Particulars to be given where necessary. In all cases in which the party pleading relies on any misrepresentation, fraud, breach of trust, willful default, or undue influence, and in all other cases in which the particulars may be necessary beyond such an exemplified in the forms aforesaid, particulars with dates and item, if necessary, shall be stated in the pleading terms. The term used is if necessary, madams.
It was not necessary.
Madams, I have come to that. It is evident from the aforesaid provision that only those particulars are to be mentioned in the plaint which are necessary for proper adjudication of suit. In the instant case, the plaintiffs in para 7 and 8 of the plaint have made a specific averment on fraud. Further, the allegation of fraud has also been clearly stated in para 18 and 27 of the statement on affidavit of plaintiff number 1. Furthermore, the averment of fraud has also been stated in para 8 of the statement on affidavit of plaintiff number 2 and also in para 2D and 6 of the written statement filed by the performer defendant. Well, the date of discovery of fraud is not necessary in the instant case because of the following reasons. The reason being, well, I am not claiming benefit of section 17 of the Limitation Act. That's why my suit was very well within limitation. So even if we assume that I have not given any particular date, that is not required.
You just tell us. Your entire case, as per paragraph 10 of the plaint, was that no, not para 10, para 7. That this money was given for the purposes of using the business of the partnership. Correct? And then you inquired into the entire financial position, the documents of the partnership firm, and you came to know that this amount was not invested in the partnership. Does it require examination of the documents, accounts, the business of the partnership firm or not? Who will disclose, and from where do we get whether this money was actually invested or not invested? Unless the records of the partnership firm is placed before the court.
The reason being it has not been brought on record. Because Bellows may kindly come to exhibit 1. Because the partnership firm never started Bellows. Even the name was not given. Bellows may see some
Who
clause
will-
in Bellows.
who
Even
will
the
give-
office was
You
not
see,
opened.
if the-
There is nothing Bellows. in
Why
record.
didn't you
Even the
s-
capital was not pulled in.
Then why didn't you sue for accounts?
Because the firm was also not opened, my lord. There is no firm, there is
You-
no name, there is no account, nothing. my lord.
Unless the
No
bank
capital was
account is
investment.
unless the bank account is open,
Even-
the firm does not exist.
Even there is no name of the firm.
Unless the bank account is open,
But
the
that is-
firm does not exist.
Well, if the capital at least has to be pumped in. That has also
The
not
capital
been
is
pumped in.
there, 7 lakhs and 7 lakhs each and whatnot.
My lords, may
It is
kindly
already
see that.
there.
My lords, may kindly see the clause 4. Clause 4 and clause 6. The capital was to be invested, and this capital can be invested only in the account of the firm. my lords.
No, 7 lakhs each you had already contributed.
My lords, it has not come. my lords.
That
That-
was your case.
It was not at 7.5 lakh we contributed. my lords. The amounts are different. The table is there, my lords, at page number at para 5 of the plan.
You see,
There is
5
nothing
lakhs
like
you
7 and 5
invested,
lakhs, ma'am.
5 lakhs you invested for the partnership firm. You have stated so in your plaint itself, isn't it? Money receipt was given to you. Correct?
But the very case is that he had taken this money to invest in partnership. He used it. He didn't put it there. And he admits it because he returned checks of 10 lakh rupees
No.
in the name of
That
Samir.
is not merely because he issued a check, that is not an admission. The point is he took money for the purposes of investment in the firm. Whether this money was invested in the firm or not, the only manner it could come to the forefront was the accounts of the partnership firm itself.
But no account at all is there. He was only included us in that partnership. There was to be an office at some place. Nothing was there.
Is it
It has come in
the
my
law?
disposition,
Is
ma'am.
it the law that no money for running the partnership firm can be invested without there being a bank account?
It is not a law.
ऐसा लॉ नहीं है ना?
नहीं
नहीं है ना?
नहीं
कहाँ लिखा है कि बैंक अकाउंट के ही रूटेड थ्रू पार्टनरशिप बिजनेस में पैसा लगेगा? ऐसा तो नहीं है.
but
You see, please appreciate this. There is an allegation that you gave money and he did not use it in the firm. Correct? Unless the records of the firm are placed before the court, how can a finding be recorded that it was not used in the firm?
but the dependents
Is there any finding that the money was not used for the firm?
well, there is an allegation that has not been
That is only
controverted
an
and the
allegation.
depend-
Controverted means what?
Well,
They admitted that
they have not admitted
that
it.
Samir Kumar Yadav had diverted the money.
well, they have not admitted it per se, my lords.
Yes.
But they have not even been examined. They have
So
not brought on any record.
essentially it was for the accounts only. And accounts की जब बात आती है ना, तो there are so many things involved in the partnership. आखिर वो पैसा आप देखिए, समीर कुमार यादव तो चले गए, राइट? आपने चेक दिया, चेक एंड कैश हुआ, लेकिन उनका बैंक अकाउंट एग्जिबिट नहीं कराया. उनका बैंक अकाउंट एग्जिबिट कराया कि उसमें कब डेबिट एंट्री हुआ?
But
नहीं
I am
नहीं
not in
आप
position to debit the bank.
no you
So
can
this-
call, you can phone when he is not there.
Well,
You
it
can
is for
call.
the defendants.
No. Bank account you can
There is
can
one
ask.
exhibit with respect to that, my lords. That is exhibit A. There is a bank account statement which shows directly debit in the account of Samir Kumar.
Debit credit
Credited to Samir Kumar.
debit entry दिख रहा है.
Well, that is the account is of Samir Kumar Yadav, who is no more, my lords.
So
And it
account
is-
में vanish
and
हो
when
गया.
I will be-
आप किसी के ऊपर allegation of fraud लगा रहे हैं who is no more.
Well, his accounts, the defendant number 1 and 2 must be having his account and all his details. my lords. They could have brought that forward. They didn't bother to bring on record
It
any
was
document.
your case that he has diverted the money. It was your case that he has diverted the money. You have not produced any evidence to show as to where did he divert the money. You only say that you paid the amount and then he diverted the money and he died.
Plus, he received the amount, and that's why he made part payment also.
Diversion, received the amount, diversion कहाँ है?
Then, my lords, in that case, at least on the very basic matters, the presumption under 118, though generally could not be drawn in normal cases, but still I have come across judgment which says that it cannot be completely overruled in a money suit, my lords. There is a presumption under 118 that he must be having some liability towards me. In this case, by issuing a check
देखिए
of
आपकी तरह तो विद्वान की तरह हम नहीं बोल पाएंगे that there is a judgment and there is something. इस तरह से नहीं कुछ बोला, जो चीज़ आप नहीं प्लेस कर रहे हैं ना, ऐसा जजमेंट है. लेकिन in a guarded manner, what you are looking for is the accounts of the partnership.
but my whole issue is, my lord, that by returning me rupees 10 lakh, he admitted that he owed me something.
29 lakhs तो नहीं रिटर्न किया ना,
10 lakh return किए.
तो फ्रॉड कहाँ से हो गया? बेचारा रिटर्न तो किया.
But that was not encashed.
That's your
He didn't
problem.
allow me to encash it, my lord.
Allow मतलब क्या? आपको
He
बैंक
himself
में
that
आपको बैंक में चेक डालने से कोई रोक सकता है?
but he himself requested not to put it. There was a specific pleading to that effect, my lord.
That's right.
Because he was ill, he requested me.
ऐसा नहीं है ना कि उन्होंने नहीं पेमेंट किया, उन्होंने पेमेंट किया.
But it,
Fraud is a very strong word. Stronger the word, more is the onus of proof. The very fact that he returned itself indicates that it was not a fraudulent transaction. It might not have been utilized. जो वो रिटर्न कर रहे हैं इससे क्या इंडिकेट करता है? पैसा है लेकिन यूटिलाइज नहीं हुआ. पॉसिबल? डाइवर्ट कर दिया कहाँ से बोल?
well,
You stated that the entire amount has been diverted.
well, that's why, my lord, kindly see the pleadings. There he says that when I confronted him with the fact that you have not invested this money in the particular firm or you have not purchased any land, then thereafter he said that my evidence is also there. My lord, particularly see.
कौन
my
क्रॉस
deposition.
एग्जामिन करेगा इन सब बातों
I was
का?
cross-examined, my lord. I was cross-examined.
कौन
It has come in
करेगा?
my cross.
जिसके ऊपर आप फ्रॉड का एलिगेशन लगा रहे हैं कि उन्होंने ये बोला और ऐसा बोला, he is no more.
My lord, may kindly see just one paragraph. My lord, para 43 of my deposition, cross-examination. My lord.
ठीक.
मैंने स्वर्गीय समूर कुमार यादव को उनके जीवन काल में कोई दीवानी या फौजदारी मुकदमा नहीं किया. स्वतः कहते हैं कि अपने जीवन काल में समीर कुमार यादव एग्री कर चुके थे कि मैं आपसे पैसा लिया है, जो आपको पैसा थोड़ा थोड़ा करके वापस कर देंगे. इस बात की जानकारी उनकी पत्नी को भी है. So he is a defendant in this case, and the defendant has not been even examined and he has not controverted this fact, which I have been brought on record in cross-examination. Well, just two paragraphs of my evidence
The
submission.
wife was examined.
She didn't came before. She didn't participate. After filing WS, well, she didn't participate.
It was expert.
No, well, she filed WS, but she didn't came for examination. She didn't bring any document on record.
There was no participation. Nothing.
No,
evidence.
nothing.
No evidence.
They have not controverted any of the allegations that have been made.
In the written statement, everything stood admitted.
No, well,
Denied.
they
They cross-examined your witnesses.
all the three witnesses have been cross-examined.
Okay.
Well,
That's all.
well.
आपको मालूम है सबसे ज्यादा
एक महीनों से
सबसे ज्यादा कॉम्प्लिकेटेड फाइनेंशियल क्या बोलते हैं फ्रॉड ट्रांजैक्शंस झारखंड में सबसे ज्यादा कॉम्प्लिकेटेड. If you see the banking sector and if you see the nature of fraud, you will be astonished. एक लैंड का 4 ओरिजिनल डीड. देखते रहिए कहाँ से. आप तो देखे होंगे बहुत सारे.
Your lordship must have
I have seen it. I have seen all the 4 at a time रखा हुआ.
But as
एक क्लैरिफिकेशन था मैंने एग्जिबिट 2/2 पे, उसमें एक चीज पॉइंट आउट हुआ था ऑन द लास्ट ओकेजन दैट देयर इज अ मिसमैच बिटवीन द इशूइंग डेट ऑफ स्टाम्प एंड द डेट ऑफ मनी रिसीव्ड. With respect to that, I have to give a clarification. If my notes, kindly see annexation 2/2 minutes.
that
Exhibit
I have
two by
not
two.
given in
उसका
my
क्या relevance
notes.
उसका क्या रेलेवेंस है?
But just to clarify. Otherwise, if it is not required, then I will.
Your lordship, 2 judgments which your lordship had said on section 8 and could be the impact. These are the two judgments which I relied on.
इसको ऐसा करेंगे, ये बंच बांध दीजिएगा अलग से और ये बंच अलग से, ये आपकी लाइन ऊपर रिस्पॉन्डेंट लिखी है।
First 2009 volume 10 SCC 103 para 17 and 18 is important.
क्या बोला उसमें?
Very short, I'll place
Just tell us what is it.
absolutely mandatory to refer to the parties for arbitration. Para 18 says section 8 is in the form of a legislative command to the court, and once the prerequisite condition as aforesaid are satisfied, the court must refer the parties to arbitration. As a matter of fact, on fulfillment of the conditions of section 8, no option is left to the court, and the court has to refer the parties to arbitration. There is nothing on record that prerequisite of condition of so and so are not fulfilled within the present case. Therefore, in this
No,
circumstance,
their cases, the question of referring would have come had there been a petition under section 8. इनको यही condition.
that is it.
तो
And-
उसी पे decide.
And
Then
the
that
second
is
And
one,
there are two judgments which they have cited
yes,
that अगर नहीं फाइल होंगे तो नहीं चलेगा. So,
और एक है 2015 वॉल्यूम 14 SCC 444. In this para 8 again, once there is an agreement between the parties to refer the dispute and differences arising out of an agreement to arbitration, and in case either party ignoring the terms of the agreement approaches the civil court and the other party in terms of section 8 of the so and so moves the court for referring the parties to arbitration before the first statement of substance of dispute is filed, in view of peremptory language of section 8 of the Arbitration Act, it is obligatory for the court to refer the parties to arbitration in terms of the agreement as held by the court in so and so. And then para 13. Once an application in due compliance with section 8 of section Arbitration Act is filed, the approach of the civil court should not be to see whether the court has jurisdiction. It should be to see whether its jurisdiction has been outstepped. There's a lot of difference between the two approaches. Once it is brought to the notice of the court that its jurisdiction has been taken away in terms of the procedure prescribed under the special statute, the civil court should first see whether there is an ouster of jurisdiction in terms or compliance with the procedure under the special statute. The general law should yield to the special law so and so. In such a situation, the approach shall not be to see whether there is still jurisdiction in the civil court under the general law. Such approaches would only delay the resolution of dispute and complicate the
we
redressal
have
of
to
grievances.
decide the issue as to whether on the moment the court comes across an arbitration clause in the agreement, whether the court would have the power to suo motu exercise
And
that power and dismiss the suit. You see, there are two things. If nobody is asking for a reference to arbitration, the court would dismiss the suit as not legitimate, would not refer the suit for arbitration. Correct? Reference will come only if there is a section 8.
compliance is there, section 8.
Yes.
But-
If nobody is asking for a reference, parties may choose not to ask for a reference.
But
But
if
whether in that case the suit will be entertained, उसके लिए arbitration and उसी का act को ही examine करें,
हाँ ठीक है.
जो
But
हमको करना पड़ेगा.
yes, but once the separate application is not filed and the ingredient is there in the main written statement itself, then this technical argument cannot be made that a separate application has to be made.
Mr. Rahul Sinha, there is a difference between the two. One is, तब तो बहुत अच्छा है कि आपने एक petition file किया, and then the other side did not choose to object or did not choose to file any petition for reference to arbitration, correct? And then later on, a point is raised that it is barred by law. When it comes to a point that it is barred by law, then the court under arbitration has two options. Section 8 का होगा तो arbitrator के पास रेफर करेगा, dismiss नहीं करेगा suit. The matter will be referred for arbitration under section 8. लेकिन अगर कोई पार्टी नहीं फाइल करता है, the consequence will be that the suit will be dismissed as not meeting. Then suo motu court will not refer it to arbitration. The court would only say that it is not meeting because of a statutory bar. वो statutory bar हमको खोजना पड़ेगा. Arbitration Act में है कि कहाँ पर है कि हम उसको statutory bar उसमें read कर सकते हैं. फर्क है ना दोनों में.
फर्क है.
Reference नहीं होगा.
नहीं, यहाँ थोड़ा डिफरेंस ये है that
For rest of you, I have some very important work. आज 5 बजे तक नहीं बैठ पाएंगे. I will not be able to do your orders cases. It will be listed. Maybe I hope there is no urgency in any of the orders matters. अब छुट्टी के बाद ही इसको लिस्ट करेंगे. ये सारे orders matters छुट्टी के बाद जाएंगे. जिस दिन भी जाएंगे उस दिन जो है ये मैटर सारे के सारे राइट 2:15 बजे टेकअप करेंगे. जितने भी ऑर्डर्स होंगे हम लोग कर लेंगे. आज नहीं पॉसिबल. नहीं अभी नहीं कर सकते. क्या होगा बैच के साथ नहीं भी आएगा तो जो बैच में रहेगा उसको डिसाइड कर लेंगे. काउंसिल तो सब एक ही है ना. जितना रहेगा उतना डिसाइड कर लेंगे. नहीं छोड़ दीजिए आज प्लीज, हमको थोड़ा सा जल्दी ही ठीक है. इस पे हम सोचेंगे.
ठीक है. और एक लास्ट ये है that no liability can be fastened upon legal heirs of the deceased partner. So this is also one
Deceased?
of the deceased partner. No liability can be fastened upon.
Unless they inherit, unless there is a clause of inheritance.
Absolutely.
पार्टनरशिप में अगर मान लीजिए किसी का डेथ हो जाता है पार्टनर का, then the legal heirs automatically gets a right by virtue of the provision of law.
In 42 it says that
Yes.
on the death of the partner, it would actually the partnership would dissolve
Devolve.
and the other two partners they can reconstitute a fresh partnership amongst them.
और legal heirs का क्या होगा?
Legal heirs they would not have a liability on the partnership. That means they would not be liable for any loss or whatever accounts of the firm.
और
Because
उसका पैसा रहेगा तो,
पैसा रहेगा
क्लेम रहेगा
तो वही तो डिसोल्यूशन ऑफ फर्म के लिए अगर सूट फाइल होगा इसमें वही है. बहुत क्लियर.
ठीक है दीजिए.
Para 16 हो.
एक आप लोग से रिक्वेस्ट है, जो जजमेंट आपने साइट किए हैं ना, ये ऊपर ना सारे में पैरा नंबर लिख दीजिए.
अच्छा ठीक है.
कौन कौन सा अभी
ठीक
लिख
है, अभी
दीजिए. लिख दीजिए इसको. इनका पूरा बंच इनको दे दीजिए और उनका आप भी अपना पैरा नंबर तो आपने लिखा ही होगा.
सब कुछ लिख दिया.
इसको रखो. Arguments concluded. The learned counsel for the parties have also submitted short synopsis of the points which they have argued before this court. And they have relied upon following judgments. आपका भी judgment एक जगह कर देंगे, इनका भी कर देंगे with paragraph number concluded.